the issue has been proof of treatment victim impact panel. For a little bit of context, so the chemical dependency evaluation that was filed recommended a relatively low level of treatment. It was an hour and a half group once a week for 6 months, AA meetings, 3 individual sessions, I believe, for the 6-month period in the victim impact panel. At the last hearing, Mr. Westmoreland spoke about how he was sort of doing an internal dispute with those recommendations with some higher ups at the agency. The agency escapes me, which one he was at. Stop, I think. And the court gave him some time to sort of have that evaluation sort of reevaluated. He has had a conversation. He has been working with them, but I guess that's a longer process. Long and short of it is that's still outstanding. The victim impact panel, though, is also court required, not just the evaluation. And so at this time, what defense is asking here is, and slightly different based on that information that State and I talked about, so forgive me. Our request would be to have sanction for a period of community service for not having the victim impact panel done. At this point, requiring the victim impact panel as an ongoing condition, since that was in the evaluation and court ordered, and waiving the follow-up treatment as a compliance, as a probationary requirement. And the reason we're asking for that is, number one, while the plea of guilty here was in 2022, this was an incident stemming from 2015. The case was filed in 2017 and the plea of guilty was in 22. There has been, I believe, a driving with a suspended license in 2019, but essentially there's been,
which is on warrant status.
That's correct, Your Honor. But from 2015 until now, there has been no, no subsequent DUIs, nothing indicating, substance abuse issues that at least lead to any kind of criminal conduct. Again, the disputed evaluation has a relatively low level of recommended treatment that Mr. Westmoreland is going through their internal process of sort of challenging. So we're wondering, given not necessarily the age of the case, and we're not asking to close probation. I believe probation would still be through January of next year. But just at this point, requiring the victim impact panel proof, and then no new law violations throughout the rest of jurisdiction, and then complying with whatever community service is imposed as a sanction for not having that done at this point. That's the request of defense. And then Mr. Westmoreland also asked to address the court on that front.
So I guess I'm a little unclear. What do you mean by dispute with higher ups? I mean, my recollection of this is Mr. Westmoreland was here not too long ago saying he was told by them, hey, you didn't need any treatment. And now, of course, we have the evaluation that says, yes, you do. And I think there's another document in here that says, I told him that that he needed to do it. So I'm not sure is he trying to get them to change their mind from the recommendation? And by the way, just because a bunch of time has passed doesn't mean the underlying issue with Mr. Westmoreland has passed. Again, I think, was this like a 0.2 something on a DUI? Or not? Maybe if I'm wrong, I'll correct myself on that. So what was the BAC in this case?
I would have to go back and look.
Yeah, 0.224. It was in the evaluation, which is kind of up there. And so I'll have you explain to me what exactly you mean by a dispute with the higher ups. If I misphrase, if I'm maybe paraphrasing what you say, but I'm not sure exactly what that means. And then I'll hear from Mr. Westmoreland.
For your honor. Yeah, so my understanding is Mr. Westmoreland went back to the evaluator who did the substance use evaluation that he disagrees with, and that evaluator stood by the evaluation. I believe that's what's reflected in Laserfish. And then he was able to then speak with, and this is where actually Mr. Westmoreland might be a little more helpful, because I'm not entirely sure of the process, but my understanding is that there was someone else within STOP. He was able to go and ask to have an internal review of that document. And that review is currently pending. That's sort of where my understanding of how this work ends. So I would sort of defer to him on that. But so my request though would stand. I mean, it sounds like, you know, Mr. Westmoreland is disputing a chemical dependency evaluation that that does require certain affirmative steps from him. I just think in light of this ongoing internal dispute that he's having with STOP, I understand that, you know, it sounds like that was a higher end BAC. I think the fact that there hasn't been any subsequent conduct similar to that is notable. I think that the level of recommended treatment, you know, was again on the lower side of what he needed to do. Also maybe demonstrates that with the victim impact panel class and with no new law violations through the end of jurisdiction, that hopefully would satisfy the court that he's being law abiding, that he is addressing underlying issues, and that he's, you know, willing to do some community service here as a sanction for what non-compliance has happened up till this point.
In the victim's impact panel, still it hasn't been done.
That's right.
Right.
Yeah, that's right.
So is it possible, I guess, that he just doesn't want to do these things?
Well, Your Honor, I know he wants.
I kind of, you know, maybe if you disagree, we have people disagree with evaluations all the time, but the victim's impact panel, that's just, you just show up and hear testimonials of people who've been affected by DU. I mean, that's not any sort of treatment. That's
right, Your Honor. And that's actually, well, I'll defer to Mr. Westmoreland because he has some pretty positive things that he wants to say about taking that class and wanting to do community service. And as he'll say, sort of finish jurisdiction on this on a very positive, constructive note. So he is actually pretty eager to do the victim impact panel, but I'll turn Mr. Westmoreland, if you want to speak, I'll turn to you now. You're on mute.
Go ahead, Mr. Westmoreland. You can unmute yourself. And then I'll hear after what I hear from you, I'll hear from the state.
Okay. Can you hear me now?
Yes.
Okay. What I wanted to correct a couple of impressions. One of them is that no, when I spoke with the evaluator who evaluated me, when I said that she stood by her decision was that I didn't have a problem at all. That was what her decision was. What happened was when we were after that, they have a standard internal review they do of every counselor's decision. She's been there for a number of years. She and I had probably an hour and a half together. She found that I didn't have a problem. I don't and haven't.
So hang on just a second. Let me see if I understand this correctly. Are you telling me then that she told you one thing and then wrote up a written evaluation inconsistent with what she told you, verbally?
No, someone else wrote that. The one that she wrote said that I didn't have an issue. That's what she told me. And then I talked with her again and she said, yeah, that's true. But what happened was they have an internal review process of every decision they ever make, apparently.
Okay, so hang on just a second. So she's saying she wrote an evaluation that said no treatment. Her agency reviewed it and then changed it?
One person at her agency, yeah, the owner changed it. And so we went to court, and then last time you and I spoke, I told you what I told you just now, is that that's what she did. And so the internal person just overdid it, overturned her original evaluation. So it was like an appellate court went in and overturned a trial court decision. So I talked with this person again, with the person who actually did that. And then so he was like, okay, I get it. So he says, well, I'm going to go through and evaluate it again, my decision to overturn her decision. So the appellate court, in a metaphoric sense, said, okay, well, look, we're going to reconsider what we just did here. We're not so sure. And so right now I'm just waiting for him to get back to me, because I think that a mistake was made. And as far as that goes,
How come you haven't done the victims impact panel after all these years?
because there's always a reason, right? There's no reason to not do it, except my mom just died about 3 weeks ago, and I was going to do it. And I've been, that is a suspicious circumstances death. And I've been doing a lot of work with the pathologist. We hired a family pathologist, and I haven't had time.
Did you say that was 3 weeks ago?
Yeah, yes.
Well, I mean, what
2 weeks,
about,
2 weeks
first
ago.
of all, I'm very sorry about the loss of your mother. The loss of a parent is a very difficult thing. And I do feel I'm very sympathetic to that, but you've had a number of years prior to that when it wasn't been done either.
Right. Like I said, there's always been a reason. I'm happy to do the victims impact panel. There's always something going on. I have lived out of state for a number of years, so I have only been back here for about 6 months. But and I have not had time to do it. It's just been one thing after another. But I am going to do it. I'm happy to do it. I want to do the victims impact panel, and I want to do community service. I just want to end this whole thing on a positive note.
Okay.
Community service sounds great.
When do you expect to get an answer from the higher up there with regard to, I'll use your word, the appellate court at the treatment agency?
I don't know how else to phrase it. I don't know. He didn't say, but it's such a weird thing to do anyway, because the counselor found that I didn't have an issue. So when I came to court last time, that's what I was
Well,
expecting.
it is weird, Mr. Westmoreland. I'm telling you, I've been doing this job for a number of years now. I've never heard of anything like this before.
Yeah.
So I agree with you that it's weird.
Yeah.
And the second thing is, I'm going to hear from the state, but I would not be enthusiastic about just saying, no, well, enough time has passed. That's all right. You get a pass on this deal. I mean, this was evaluation. This is there. I can't imagine why anyone would want to work at a place where they do a job, do a report, construct a report, and somebody else says, nope, that's not it. Put your signature on something you don't believe in. I don't understand why someone would stay there to do that, first of all. You said there's a process ongoing with that agency. Well, let that, it is to your credit that there hasn't been any other serious violations of the law. I'll let that process play out. But I think you're going to have to come to terms to the fact that you're going to have to do, and as Mr. Stillwell said, the requirements, given what we see with regard to these evaluations and what's required, these aren't that onerous. So go ahead. I appreciate that you want to end this on a positive note. And the most positive note is to get your victims impact panel done and do this program that's been recommended.
Well, the program, honestly, I mean, this is where part of the dispute is. The focus shouldn't even be there. I don't have an issue. I've made a mistake. That's, this is a situation where the person who is actually the professional counselor decided that I don't need the program. It's a waste of time. I mean, I'm not a drinker. I've never been one. And it's just like, why did you go in here and arbitrarily? It made me ask the question, do you ever not recommend this program for someone? It seems kind of almost an opportunistic grab. On the other hand, on their part, something like community service, this has been going on for 8 years. It took 2 years to file charges.
I know. And had you completed got an evaluation and completed your program in a timely manner, this would have been done with years ago.
I wish I had not lived out of state for years. The thing is, it's like I am the one that started this a long time ago in 2015 when I made a stupid mistake. And and I get that, okay, but as far as the, if it's a conversation, there's an argument over whether or not to do an alcohol program that isn't needed, that this won't ever be something that we resolve, and I will go do that, but it would just be with a lot of resentment, because it would just feel like the stop program making money and opportunistic grab. The counselor made their decision about me needing treatment, and that's the whole point of it, is treatment if you need it, and I don't need it, and I'm happy to do the community service. Philosophically, I think it's a beautiful idea, to serve your community. I'm happy having that be part of a sentence for something stupid. I think that, a 6-month alcohol program is a misfocused way of applying. I don't want to say, I don't want to overstep here. I just don't think it's not a thing in my gut that feels right. Community service, on the other hand, does feel right, and victims impact panel certainly feels right. I did a stupid thing, and I would love to hear from people who have been victimized by people like me who've done stupid things and didn't put enough forethought into it before they left the bar. I just feel like that would be a more appropriate outcome.
When was the last time you spoke to someone from that agency?
It's been about the time I was crying when he called, so 2.5 weeks ago.
All right.
And I think it's some
Ms.
kind of weird ad hoc thing. I didn't even know it could be done.
Ms. Ferris, anything you wish to add at this time?
I'm sorry, I'm not aware of Mr. Westmoreland's case.
Thank you. Mr. Robbins?
Your Honor, at the moment, there's an evaluation that says he needs treatment. We've always prioritized treatment, and until it says something different, the state feels that that should be enforced.
It's like was even.
So, and again, I have right in front of me there, Mr. Westmoreland. It's signed by the counselor, the person who did the assessment. I attest that the information, the evaluation to be accurate and truthful representation of the information I provided during the assessment process.
That's not.
I
true.
also
That's
understand
not
that the results of my assessment may change should the program receive information that was undisclosed by me at the time of the evaluation. Your signatures on that, the treatment providers on that. And so, this isn't going to go on forever. And what's going to happen is, again, you say you've got some sort of process. We'll reset this for 1 month and then that's it. And if you still don't want to do it, we're going to do something else, and it won't be community service, and you probably won't find it all that pleasant.
It's not even.
But you need to get that. That's, and then you need some documentation of what's actually happening with this treatment agency.
Yeah,
Some letter from someone saying, yes, we're reviewing this, or something like that.
Yeah. No, of course, if it ultimately came down to it, then I would comply with the court's order.
Then
That
it's
is
coming down. I can tell you it's going to come down to it. I
Yeah.
can tell you that right now.
I'm not sure what but anyway, if she's saying that that's what she found, then she must have signed that after the guy above her.
It looks to me like you and her signed it on the same day, on May 18th of 2023.
That's not how it went down. I don't have any idea which form that is, but when we walked out of there, we talked about it.
All right.
And what I'm telling you is true. That is what she found when we were walking out of the place. She told me that you don't need that. You just go to the victims impact panel. So that makes me look like I'm a liar, and I'm not. When we had our counseling session, she told me that we did fine, and I did fine. I don't even drink. It's not even something that's part of my life.
What do you want? October, maybe mid to late. What's that? Yeah, maybe about 5 weeks. Okay, October 5th.
I've never lied to this court.
Okay, so I would concede that maybe you have a misunderstanding what was told to you, but I'm trying to clear up that misunderstanding. The
Okay.
report says you got to do this program. That's it. Maybe you misunderstood. I'm not accusing you of lying. Maybe that was miscommunicated. I don't know. But until we hear otherwise, that report is, that evaluation is there. You're going to need to comply with it. And you had said earlier, you know, if it comes down to it, I guess I'll have to do it. It's going to come down to it where you have to do it. Unless we get some documentation or letters from them that says, no, we're changing our mind on this. Let's do something else.
Yeah. Or they're changing their
right.
mind, now they're changing their mind. Yeah.
Are we,
Yes, I get,
are we clear on what's going to happen here?
we're very clear.
Great. That's it for today. We'll set this
Okay.
over to October 5th and then we'll deal with it then.
Okay, and let me
Okay.
make sure I understand clearly. We either need
At
from
10
this
a.m.
agency. Hello?
Yeah, I'm here.
Oh, okay. I just want to make sure I understand clearly. So by October 5th, it needs to be a situation where either I will have started this alcohol thing, or we have a letter from them overturning of the original counselor's decision.
Exactly.
Okay, gotcha. All right. Thank you.
And the victims impact panel. Don't forget about the victims impact panel. That
Okay,
sounds like a
good.
point of an agreement. You should be able to, you know, you agree you need to do it and we're wanting it. You know, I don't see any reason why that, well, I'm not going to get into that, but you,
No, I'll do
very
that.
least you
That's
should
fine.
get that done.
Yeah, no, yeah, absolutely. I'm going to. Yeah,
All
I
right.
still have a really bad feeling because that's not what she said. So I don't know why. I
Mailing
need to find
address
it
still
for-
on Midvale Avenue, number 201 in Seattle.
Correct. Yes, sir. Yes, Your
Did you
Honor.
get a text reminder of this court date?
I did, and I appreciate having those.
All right. That's it for today. You're free to leave the
Thank you.
Zoom call. We'll see you
All right,
back here on the 5th.
All right, have a good night.
Thank you.
Good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. At this time, we've sent to the matter being heard via Zoom.
Okay, thank you. All right, and ma'am, Ms. Solomon, please unmute and state your name for the record.
Kenya Solomon.
All right, and so today's the date scheduled for probation violation. You're currently on probation for operating while visibly impaired, and it's alleged you failed to appear for drug testing on July 15th, test positive for alcohol July 17th and July 30th, and you were sentenced in this court on June 28th. So all within the first 30 days, there's 3 violations. And counsel?
Your Honor, I've had an opportunity to review this matter with my client. She will not be requesting a violation of probation hearing.
Ma'am, please raise your right hand. Do you solemnly swear from the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And so, counsel. I'm sorry, Ms. Solomon, you heard the allegations that were placed on the record, correct?
Yes,
And as to those allegations, how do you plead?
guilty.
And you've gone over your advice or rights for probation violation purposes, correct?
Yes,
And as to those allegations, how do you plead?
guilty.
Oh, I'm sorry. You understand by entering into a plea that you'll be waiving some of those rights that you've already gone over, specifically your right to a contested hearing.
Yes,
And you also understand the possible penalties as a result of your plea, correct?
yes, Your Honor.
Specifically, the recommendation here is for you to continue your probation, pay a $50 probation violation fee, increase your testing, and 15 days jail. Do you understand that?
Yes,
And that recommendation is based upon your sentencing order that was there was mandatory jail for any violation. Do you understand that?
yes,
And knowing all that, you still want to continue with your plea?
guilty.
Okay. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right. And counsel, if you can please pardon your client.
Yes, I'd like to direct your attention back to July 15th. Did you fail to take a test as ordered by probation? It's a drug test on July 15th, 2023, yes or no?
Yes,
All right, and then a test that you took on July 17th, it indicated the use of alcohol. Is that accurate?
yes,
And then the test that you took on July 30th of 2023 that indicated the use of alcohol. Is that correct?
yes,
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea to probation violation, indicate technical violations 1, 2, and 3. Will enter and counsel as to the recommendation.
Your Honor, I've had an opportunity to review the recommendation. I saw that there's a recommendation for increased testing. I saw that there was a recommendation for jail to have no review. I would be respectfully requesting consideration for there to be a review date on that. She indicates that she will comply with any and all terms, conditions, that she will have no further missteps, and that she will make sure that there are no issues with probation going forward. Thank you, Judge.
Okay, well, so, ma'am, you weren't even on probation
yes.
for 3 weeks. You failed to appear for your drug test July 15th. Why didn't you appear for your drug test?
Because I was with a guy and he put something in my drink, and that's the reason why I had broke up with him and I'm done with him, because I paying the court so much money. I'm not trying to mess my life up. I'm not trying to go to jail. I work, I got my own house, and I'm not trying to lose everything. So I had to get rid of him. So I'm done with that. I'm trying to get my life together. I'm in counselor right now. I'm doing my counselor and stuff. So I'm just trying to be on track, you know.
Okay, can you please stop walking around, ma'am?
Okay.
So I'm sorry. What, so you didn't appear because you knew you were going to test positive?
Excuse me?
So you didn't appear because you knew you were going to test positive?
No, I did not. I didn't have a ride to work. I know I could get in a lift and stuff, but I ain't had the money at that time because I'm paying the court. I was riding a bike. It's like 4 miles away from my house, but my bike got on flat. So now I got my bike fixed. So ain't nothing to be worried about. I'm gonna be on time, going to my testing. You know, I'm doing my counseling, whatever the court needs me to do, I want to do. I want to be on the right track, not, you know, on the backwards. I want to go forward. So I had to leave the man alone that made me, he told me he gonna put me in jail. He put liquor in my drink when I was drinking, and I turned out positive, you know? So I didn't know to my
Okay,
probation
so
officer.
ma'am, hold on.
Uh-huh.
When did the person put something in your drink?
Yes, my boyfriend, he an alcoholic. And he drink. So he put something in my drink. I didn't know till my probation officer told me that I violated. When she told me, I was shocked. You know, I don't do things like that. I'm trying to get myself together. I've been paying the court, and you know, I'm not trying to mess my life up.
So, ma'am, what were you drinking that he
I don't even know
apparently
what.
added alcohol to?
I don't know. Because he said he gonna lock me up. I'm going to jail. Oh, you gonna go to jail. I don't know what he put in my drink. I don't know. But he wanted me to go to jail. That's what he told me. Oh, you gonna go to jail. I didn't believe it to my probation. My probation said you violated and you've been drinking too. I'm drinking. You know, I've been going testing all this time and I ain't had no drink in my system. You know, for these 2 days I had drink in my system. So I was shocked.
Ma'am, pause. You just testified under oath that you tested positive on July 17th because your boyfriend put something in your drink.
Yeah.
So what is it you were drinking that he added alcohol to?
He drank vodka. I don't know what he had. What did he drink? I don't know what he poured in my
I'm asking no, ma'am, you're not listening to what I'm saying, please. You are telling this court that your boyfriend put something in your drink. What were you drinking? Or what did you think you were drinking before he put something in your drink?
He drank vodka, so
no, I don't care what he drinks. I'm asking you, what were you drinking that day?
Vodka.
You were drinking vodka. So you didn't appear because you knew you were going to test positive.
No, I did not. I didn't have a ride to work. I know I could get in a lift and stuff, but I ain't had the money at that time because I'm paying the court. I was riding the bike. It's like 4 miles away from my house, but my bike got on flat. So now I got my bike fixed. So ain't nothing to be worried about. I'm gonna be on time going to my testing. You know, I'm doing my counseling, whatever the court needs me to do, I want to do. I want to be on the right track, not, you know, on the backwards. I want to go forward. So I had to leave a man alone that made me, he told me he gonna put me in jail. He put liquor in my drink when I was drinking, and I turned out positive, you know? So I didn't know to my
Okay,
probation
so
officer.
ma'am, hold on.
Uh-huh.
When did the person put something in your drink?
Yes, my boyfriend, he an alcoholic. And he drink. So he put something in my drink. I didn't know, to my probation officer told me that I violated. When she told me, I was shocked. You know, I don't do things like that. I'm trying to get myself together. I've been paying the court, and you know, I'm not trying to mess my life up.
So ma'am, what were you drinking that he
I don't even know
apparently
what.
added alcohol to?
I don't know. Because he said he gonna lock me up. I'm going to jail. Oh, you gonna go to jail. I don't know what he put in my drink. I don't know. But he wanted me to go to jail. That's what he told me. Oh, you gonna go to jail. I didn't believe it to my probation. My probation said you violated and you've been drinking too. I'm drinking. You know, I've been going testing all this time and I ain't had no drink in my system. You know, for these 2 days I had drink in my system. So I was shocked.
Ma'am, pause. You just testified under oath that you tested positive on July 17th because your boyfriend put something in your drink.
Yeah.
So what is it you were drinking that he added alcohol to?
He drank vodka. I don't know what he had. What did he drink? I don't know what he poured in my
No, I'm
drink.
asking no, ma'am, you're not listening to what I'm saying, please.
Uh-huh.
You are telling this court that your boyfriend put something in your drink. What
Yes.
were you drinking? Or what did you think you were drinking before he put something in your drink?
He drank vodka, so
no,
I don't know.
I don't care what he drinks. I'm asking you, what were you drinking that day?
Vodka.
You were drinking vodka. Okay. And so on July 30th, what were you drinking?
Same thing, vodka.
Okay. And why are you drinking vodka, ma'am?
I didn't know that he did that to me.
No, stop blaming it on somebody else and take accountability for your own actions, because you know what a vodka drink tastes like. So why were you drinking vodka on those 2 occasions, ma'am?
Your Honor, I don't know.
You know, ma'am, that if you violate, it's mandatory jail. I told you that at your sentencing.
Yes.
And you went ahead and you consumed alcohol, not just once, but twice.
Yes, Your Honor. It ain't gonna happen again. I have to just get.
It for sure won't happen for the next 15 days because you're going to be in the Wayne County Jail. Ma'am, you have an issue with alcohol. You had a prior in 2008. Then you have this one. And this is a 0.26. A 0.26. And then you violated now twice. by consuming alcohol. And then you're trying to blame it on somebody else as to why you're testing positive for alcohol. You're in
Yeah.
court today.
Sorry.
What?
I didn't know he did that to me. I made some Kool-Aid. He said he was gonna put me in jail. That's what he said. He gonna put me in jail with my probation.
Ma'am?
Yes.
Ma'am, your levels would suggest that you had more than one sip of the Kool-Aid, the vodka spiked Kool-Aid, if that's what I'm supposed to believe. So what I'm telling you, ma'am, is you know what vodka tastes like.
Yes,
You
Your
know
Honor.
what it feels like after you consume vodka. So don't try putting it off on somebody else that they spiked your drink. You're responsible for that. You consumed it. You could taste it and you could feel that you consumed vodka. The sooner you start taking accountability for your own issues and actions, the sooner you can potentially be on the path to recovery. The court's adopting the recommendation. You're continuing to complete all terms of probation, pay a $15 probation violation fee, you're going to serve 15 days jail starting today, and increased testing upon your release. So you're going to email into Ms. Shaw, and she'll tell you where you need to report today by 6 p.m.
Okay, Your Honor.
Anything else?
Nothing else, Your Honor.
No, Your Honor.
All right, thank you. All right, thank you.
She's coming back on.
All right.
There you are. Can you hear me, Ms. Gordon?
Yes, sir.
Okay, so where are we at on these things that are required? It sounds like you're starting your mental health treatment.
Yes, Your Honor.
What about the domestic violence recommendation?
I don't recall them having a recommendation for me.
Well, engage in
mental
a
health.
12-week parenting class with domestic violence specific component. And then other things are kind of rolled into the other things, get a neurological evaluation, and then a substance use disorder treatment, their evaluation. And that's the other thing. They recommend a substance use evaluation. So I'm wondering where we're at on that.
Right. I lost transportation a while back. And so I've just been working on getting transportation, but I can probably knock that out here within the next month.
And then there's some issues of missed appointments with the diversion organization. There's a representative from the diversion organization here. And then is she not, do they call in or does she have to come by in person or how's that work? Okay. Okay. So what are your plans about getting the substance use evaluation there?
I'm pretty sure Comprehensive Life Resources will help me with that as well. So I should be able to try to make a move on that on Monday.
So ma'am, I'm going to kind of go around the horn here. I'm going to hear from the state. I'll hear from Mr. Stillwell's pretty much already told me, just want more time to do all this stuff. I'm going to hear from the state, then I'll maybe check in with the diversion, the pretrial diversion
Okay.
agency. Mr. Robbins, what's the state's position and where we go from here?
State makes an oral motion to revoke based on it being about a year and we're still struggling with compliance and request a PFTC hearing. Thank you.
All right. So is this diversion agreement salvageable from your point of view in the back? What do you think? Did you hear that, ma'am?
Yes, Your Honor.
What did he say?
That is up to me.
It is. Are you up to it?
Yes, I am.
All right. What are your plans on taking care of this warrant?
I have been trying to squash it. And so, I kind of left that alone for a minute, just to try to squash it again. If not, I can turn myself in and then
Yeah,
just
you
deal
need to
with that.
contact Yakima Muni and see what they can do.
Okay,
Hang on just a second. So we'll reset this. Let's go out a ways. October 12th will be your next court date here.
okay,
I want to double check your mailing address. You still live on 240th Street? No,
yes.
you live in Kent?
yes,
Okay, yeah, you need to get a hold of go over Yakima somehow. But you live on 240th Street, apartment 762 in Kent?
yes, sir. Yes,
Did you get a text reminder of this court date?
yes,
All right. So that's it. I want you to continue to report to pretrial services diversion as required also. You understand that?
yes, Your Honor.
You're free to go.
Thank you.